on that your presence and your words would really help all the participants, and we are really proud to have you Hpnlu. On behalf of Hpnlu Shimla, I once again welcome you. Thank you, Kanishka. It's over to you.
Thank you, sir. Now, I would like to introduce our honorable guest for this event, Dr. Shantanu Mukherjee, sir, who is a renowned advocate and an accredited mediator practicing in New Delhi. Sir is the founder and head of ex-Lees Chambers, Advocates and Regulatory Policy Advisors. Over the past 20 years of his work experience, he has worked in statutory and regulatory policy, commercial mediation and litigation practice, while specializing in intellectual property rights, competition law, and international trade law. Sir has held numerous senior responsibilities in and outside India, including a global tech leader MNC, as well as heading the international trade and policy practice of a Tier 1 law firm as a partner. Sir is a member of the Supreme Court Bar Association of India and International Bar Association as well. Sir, we are extremely obliged that you've decided to grace us with your presence today. The second guest for our event is Ms. Sumedha Sindhu Rathi ma'am, who is a senior partner at Lexidum and Rathi Law Firm and member advisory board at the Indian Dispute Resolution Center. She is an editor at latestlaws.com, which is one of the most followed legal journalism website in India. She has done her LLM in International Dispute Resolution from National University of Singapore. She is currently practicing in New Delhi. Ma'am, it's a pleasure to have you today with us. Next, we have our guest of honor, Ms. Anupama Walia ma'am, who is an accredited mediator in both the United States and India. Ma'am has been impaneled with the Supreme Court of India as one of the 40 mediators. Ma'am is also impaneled as a mediator with the Ministry of Corporate Affairs, Government of India, and Hyderabad Arbitration Center. A frequent speaker at domestic and international conferences, Ma'am is also a mediation trainer and has conducted events for lawyers, law students, and also for non-lawyers, and judged many mediation and negotiation competitions worldwide. Thank you so much, ma'am, for honoring us with your presence today. And finally, our chief guest for this event, Mr. Tejas Karia, sir, who is a partner with the dispute resolution practice Shardul Amarchand Mangaldas and also heads the firm's arbitration practice. His expertise spans international and general corporate advisory and diverse aspects under the information technology law, including data privacy and confidentiality. Sir has advised on the drafting of amendments to a number of key acts, including the Indian Arbitration and Conciliation Act 1996 and the Commercial Codes, Commercial Division and Commercial Appellate Division of High Courts Bill 2015. He has also been a part of the committee set up by the Government of India for institutionalization of arbitration in India. Sir, we cannot explain how happy we are for you gracing us with your honorable presence today. We are honored to have you all with us in this second national mediation competition organized by Himachal Pradesh National Law University. I want to convey my heartfelt gratitude to all of you for being here with us. Thank you so much, sir. And with this, we wish everyone a best of luck, and we want to kickstart the competition. Thank you. Before we begin with the session, I would now request Shantanu Mukherjee, sir, to please come and say a few words on behalf of his entire establishment.
Thank you very much, Professor Santosh Kumar Sharma, Director, Center for CADR and Professional Skills, distinguished academics, fellow speakers, and my dear friends, student friends, namaskar. Very good morning. My due respect to Professor Nishtha Jaswal, Vice Chancellor, Himachal Pradesh National Law University, Shimla. I'm sure that we'll get a chance to meet her sometime later. Thank you for such a vivid introduction. And of course, that's the professional part of it. Coming from dispute resolution practice, including commercial mediation for more than 25 years, that's one part of it. But the most important part for today is that I have been very much engaged with academics all through, and that has been a passion. It was none other than Professor Madhav Menon who first asked me to lecture the NUGS students. It must be 2002, and later on it has gone. I try to gone all through. I try always to take out some time and talk to students, lecture, judge moods. That is how it is. And very recently have been also started teaching my MEIG program in Geneva University in Switzerland. Thanks to the Shimla Himachal Pradesh National Law University to have me here at the mediation competition, and thanks to the organizers. I'm really humbled. First of all, it's excellent that you have a dedicated Center for ADR and Professional Skills. Although it has just started, as we heard. But it is extremely important that you have it, because this is an area of training that is essential, but I have to say very much lacking in India. Although the legal education has improved significantly over the years, but mediation as an integral part of the alternate dispute resolution is yet in a nascent stage. And the training part of it is obviously, just very recently, people have started focusing on the training. Given the effective remedy, if you say, of mediation, you will see that it is not only being encouraged by the bench, right from the Supreme Court bench, but even in the last few years, you notice that it is even being promoted through statutory reforms. Now, if you look back a little bit and see why so, you will see that typically a dispute resolution through our well-established courts of law, starting right from the court of first instance and going up to the apex, that is the Honorable Supreme Court, is an adjudicatory process. The dispute, as presented by both the parties, is heard by a qualified adjudicator, and then after addressing each point of law and fact, the order is passed. An aggrieved party can appeal on allowable grounds until exhausted on reaching the apex. So in a way, here the resolution on the dispute is passed on to the parties, forcing them to resolve it. Now, on the contrary, if you see mediation, you will see that the dispute is brought under when it is brought under mediation, a trainer mediator, as a trained mediator, comes in as a third party neutral. He assists both the parties to resolve it themselves. So the resolution is actually a natural process. Of course, it is very much facilitated by the mediator, who is a third party neutral. And I insist, I emphasize on that he or she is a third party neutral. So it would not impose decisions on the parties. So it is not adjudicated. This automatically brings us to the requirement of a well-trained mediator. Because if the mediator has to be outside as a third-party neutral and facilitate the resolution, dispute resolution, then all the parties need to confide on the mediator. So the mediator would need complete trust as a balanced, non-partisan person who has the ability to influence the parties to resolve the matter themselves. Obviously, the mediator needs to be well trained, as I mentioned, and well trained in the skills of active listening to perceive that he or she is hearing and separating the positions from the interest. And then the other important requirement is good communication skills, where particularly respecting each party's point of view is not just essential, but it is to be done through constant engagement. Now, apart from it, there are many other skills, but apart from all the other skills, one of the most important skills is negotiation. without which a mediator will remain absolutely outside, unengaged. Now, when all this is mediation, I'm delighted to see that the Himachal Pradesh National Law University in Shimla has included professional skills training along with the CADR. Because without professional training, skills training, you cannot have a 360 degrees law training. And I'm sure that the students who pass out of the university would be absolutely ready with an appropriate legal acumen, including the lawyering skills. Now we come to today, as we move on to inaugurate the second national mediation competition. All this, what I've said, all the skills of mediation of the participating team members will be put to test in a real, practical, real life scenario. And I wish I could say that I can stay on and even hop into some of the mock mediation, but unfortunately it is not possible. I wish all the participants the very best in this second national mediation competition. Thank you very much.
Thank you so much, sir. Your kind words mean a lot to us, and your appreciation was very well received by all of us. Thank you, sir. Now, I would request Ms. Sumedha Sindhu ma'am to come and say a few words.
Thank you, Kanishka. Good morning, everyone. It is my pleasure to join the inaugural ceremony of the second National Mediation Competition and be a part of such a distinguished panel. Thank you, Hpnlu, for giving me this opportunity. I'm extremely grateful for being here today. Mediation is a very important tool for dispute resolution at various levels of justice dispensation, be it at a village level dispute resolution between villagers, resolution of dispute via mediation at mediation cell at district court, high court, and Supreme Court, or be it at a complex mediation between companies resolving dispute at an international level. With respect to formal litigation system where it is concerned, mediation, along with other methods of alternative disputes resolution, has been statutorily recognized by the Civil Procedure Code, the Amendment Act of 1999, which introduced the Section 89. Legal Services Authorities Act 1987 also provides for the National Legal Services Authority as a central authority with the Chief Justice of India as its patron-in-chief. The central authority has been vested with a function to encourage the settlement of disputes by way of negotiations, arbitration, and conciliation. The Arbitration and Conciliation Act in 1996 makes elaborate provisions for conciliation of disputes arising out of legal relationship, whether contractual or not, and to all proceedings relating thereto. Mediation is an idea of immense value. It imbibes in itself a wide array of unique features clustered under one umbrella of mediation, like mediation severability, flexibility, party participation, consensus, self-reflection, preservation of ongoing relationships, and or peaceful termination of relationships. Mediation fosters peace and healthier interpersonal interactions in the long term, thereby preempting the causes of conflict in the society. The benefits of such processes as mediation are further fortified from the fact that eminent legal personalities such as Mahatma Gandhi, Abraham Lincoln, and Nani Palkiwala had taken the pleasure and pride in continually settling cases out of court, in uniting the parties driven as under by conflict and discouraging litigation. In the words of Gautam Buddha, better than 1,000 hollow words is one word that gives peace. Mandatory mediation through courts has legal sanction. Court annex mediation and conciliation centers are now established at several courts across India and the world, and they've been very successful. In court-annexed mediation, the mediation services are provided by the court as a part and parcel of the same judicial system as against court-referred mediation, wherein the court merely refers the matter to a mediator. One feature of court-annexed mediation is that the judges, lawyers, and litigants become participants therein, thereby giving them a feeling that negotiated settlement is achieved by all three actors in the justice delivery system. When a judge refers a case to the court annex mediation service, keeping overall supervision on the process, the judge refers the case to a mediator within the system. The same lawyers who appear in a case retain their briefs and continue to represent their clients before the mediators within the same setup. The litigants are given an opportunity to play their own participatory role in the resolution of disputes. This also creates public acceptance for the process as the same time-tested court system, which has acquired public confidence because of integrity and impartiality, retains its control and provides an additional service. Now, what needs to be done and to take forward the success of the court-attached mediation is to give the same sanctity and recognition to the private mediation decision that are arrived between the parties. The public confidence needs to be reposed in the private mediation proceedings to make lucrative field of mediation successful in India. This will in turn promote quality of mediators in India, and such mediators can then participate and mediate international disputes, as currently we only have a handful of mediators who can truly be called international mediators. One of the positive steps towards this is the Mediation Bill of 2021, whose salient features are to promote mediation in India, particularly institutional mediation for the resolution of disputes, which is provided by institutional dispute resolution centers like the Indian Dispute Resolution Center. It also aims to encourage community mediation and make online mediation an acceptable and cost-effective process. It proposes to bring a codified law on mediation and provide for enforcement of settlement agreements resulting from mediation, which is the basic step for promotion and success of private mediation and court-attached mediation. It is my privilege to be a part of the Indian Dispute Resolution Center as a member of the advisory board. Now, I would like to shed some light on what Indian Dispute Resolution Center is. The Indian Dispute Resolution Center has been established as a not-for-profit arbitration, mediation, and conciliation center so that it can function as an independent international organization with its own progressive in-house ADR rules. IDRC is also registered with Niti Aayog and empaneled with the Ministry of Law and Justice, Government of India. The IDRC was inaugurated by Justice A.K. Sikri on 22nd May 2020. It is the first of its kind institutional ADR center which provides all the ADR components under one roof. The IDRC provides a unique blend of both offline as well as an online ADR platforms. We have state-of-the-art infrastructure for arbitration, mediation, conciliation, as also for early neutral evaluation and expert determination, all of which is done in a time-bound and cost-effective manner. The indigenously developed eADR software has also the facility for digital signature and uploading of claim petitions, replies, and other miscellaneous applications and documents on secure cloud service with 24/7 access to stakeholders and lawyers. The proceeding sheets are created, e-signed, and saved online with auto-triggered sharing via email with the parties concerned. IDRC has conducted more than 700 online arbitrations since its inception in 2020 and is one of the leading alternative dispute resolution center in India. The IDRC's panel of domestic arbitrators and mediators come from a wide spectrum of fields and comprise of retired Supreme Court judges, retired High Court judges, district court judges, senior advocates, ex-PSUs heads, chartered accountants, and others. IDRC's overseas arbitrators consist of Queen's Counsels, barristers, solicitors from London, Singapore, Malaysia, and other countries. Empanelment positions are offered only by way of invitation to the best dispute resolution professionals. For more information, one can visit the website, theidrc.com. I feel more public awareness about mediation as an effective method of dispute resolution and introduction of statutes to provide for binding nature of decisions of institutional mediations will promote mediation regime in India. With this, I would like to conclude, and I wish all the very best to all the participants. Thank you very much for having me.
Thank you, ma'am. Thank you, ma'am, for being here and for your kind words. We are extremely honored to have you here. Now, with this, I'd like to request our guest of honor, Ms. Anupama Walia, ma'am, to please say a few words.
Good morning. Sorry. Good morning, everyone. Before I begin, I would like to thank Hpnlu, especially the Center for ADR Cell, and the organizing team for inviting me to be a part of this panel. and to get an opportunity to judge the final rounds of the second edition of the National Mediation Competition being held virtually on the 25th. Good morning to my co-panelists and a warm welcome to all the students attending this inaugural program today. I'm delighted to be here to share my thoughts and experiences about ADR, especially mediation, and the mediation competitions being organized by the universities these days. I truly and sincerely believe mediation and conciliation are the best way forward for resolving most kind of disputes. And it is this belief and my experience which makes me continue to work in this area. Obviously, not all matters that go for litigation are apt for mediation. Matters related to like fundamental rights, constitutional law, or those that require interpretation of law, or matters related to criminal law. And this list isn't by any means exhaustive. They aren't fit for mediation. But many other matters could be resolved much more effectively and efficiently through mediation rather than languishing, waiting for dates in the courts. I'm sure everyone who's here knows what mediation is and what its main features are because you have a specialized center for that. And also, as mentioned by my co-panelists. So I'll just like to reiterate what I have experienced from my practice in mediation, whether it's been in the US or it's been in India, that it is probably one of the most effective dispute resolution mechanism. We all hear that mediation is time and cost friendly, but I believe it's not only efficient in terms of cost. Of course, litigation and arbitration, we all know, are very expensive. But to me, the biggest benefit is the impact that mediation has on the lives of the people who participate in mediation and lives of those associated with them. You see, when people are involved in a litigation, whether it is of a personal nature or commercial nature, there is a lot of stress that comes with it. And that stress is not just limited to financial stress or time crunch that it leads to for managing the professional duties as well as the personal lives well, but it is of an emotional nature. When people are involved in litigation, they're always fretting about finding an advocate, dates for the litigation, strategizing with the lawyers, finding the evidence, trying to think of ways to counter what the other person might provide in their defense in the court, taking leave from work, or even making arrangements to travel to court for those dates. Litigation also impacts the relationships these people have. And when I say relationships, I mean all kinds of relationships, whether it's family, friends, or professional. It also impacts their productivity. So basically, everything gets negatively impacted when people are embroiled in litigation for so many years. It has a definite impact on their psyche, which is not healthy. So to me, the biggest benefit mediation brings about when it helps people resolve matters quickly and in a private and safe space is that it helps them get on with their lives and leave behind the dispute. It reduces the bitterness. It keeps their personal or confidential business issues from being discussed in public. And many times, it even salvages the relationships, both personal or business. It gives the parties a chance to start anew far more quickly than litigation, which feeds off bitterness. And since the parties voluntarily come to an agreement, the likelihood of their not following up with what they understood and agreed to as part of the mediation agreement is very little. Today, mediation is in the news everywhere. As Sumedha mentioned, a mediation bill has been drafted and is being deliberated in India as we speak today. The bill has helped create more awareness about mediation as a viable platform to resolve disputes across the country. You see, mediation, while it has been there as a concept and it has been practiced even in the courts since 2005, I would still say it is in a very nascent stage in India. So the bill has had a positive impact. There is also a deliberation about whether every matter before being brought up in the court should be sent for mediation to explore opportunities of settlement through communication. While some are in favor and some oppose it, and we'll wait to see what's finally decided. Nevertheless, the discussion has definitely made more people aware of mediation and comfortable, since people see that the government is supporting the mechanism. I'm thrilled that today there are so many colleges which have started organizing mediation and negotiation competitions, have introduced ADR and mediation courses. The Bar Council has mandated that every college providing the LLB course should have a course or a mediation so that the students from the very beginning get acquainted with the concept and then they acquire the required skill set. Frankly, to me, it doesn't matter even if you do not pursue mediation tomorrow. Even if you take up litigation or practice in the corporate area, these skill sets are very useful. They also help in the way you approach your practice, which would be oriented more towards creating a peaceful environment than encouraging litigation. These mediation competitions give an opportunity to the students to learn the skill sets and see how it actually works out and to meet people who are practicing it. Mediation is not just a course that you can take and read about in theory. If you want to do mediation, if you want to become a mediator, or you even want to do practice as a mediation advocate, I believe it's a skill and that can only be acquired with practice. Participating in competitions like these are absolutely a phenomenal opportunity to learn and brush your skills and practice. And if you participate in international mediation competitions or negotiation competitions and get the opportunity to travel for it, I'm hoping things would normalize and competitions won't always be organized online. You'll get to meet people in person from other countries and cultures, and you learn about their cultures. And that's extremely useful to learn the nuances of different cultures, as that plays a very important role when you're mediating between parties from different cultures. And I say that with experience, having done a lot of cross-border, cross-cultural mediations. In the end, I would just like to thank you all again for inviting me to the panel, and I look forward to being there for the competition. I wish you all the teams the very best.
Thank you so much, ma'am, for your kind words. And yes, mediation is not just for a career. It definitely is a very useful skill in our general world as well. Now, with this, I'd request our chief guest, Mr. Tejas Karia, sir, to please say a few words.
Thank you, Kanishka. Good morning, everyone. It's my immense pleasure to be here with you on this second round of this competition. I am thankful to Professor Sharma for kind words and inviting me, and also Center for ADR Cell of Hpnlu. IDRC and PACT are the supporting organizations. I've worked very closely with both the organizations, and all of you should really ensure that you become part of these organizations, because it really helps to understand and learn in the process of your journey as a student and as a professional. Uh, uh, I'm also happy that I'm part of a very distinguished panel of speakers. I heard them very carefully, and I learned a lot from that. And I'm here to share my thoughts on this competition and in mediation in general. We have seen that the mediation has developed over a period of time as a very important means of alternative dispute resolution. I specialize in arbitration, but mediation plays a very important role. And whenever we do any alternative dispute resolution, we have seen that even in the process of arbitration, we have the hybrid model of med arb med or arb med arb, which has been very, very successful in various jurisdictions, including Singapore. I sit on the Court of Arbitration of SEAC, and we have a parallel organization called SIMC, and they have a protocol where any matter which comes for arbitration, the arbitrators have to encourage parties to settle the matter through mediation. And we have seen in almost 30 to 40% cases, either the matters get resolved or the dispute gets narrowed. So once you have a narrow dispute where you don't have to fight on an adjudicatory process of arbitration, mediation plays a very important role in trying to resolve the dispute. There are obviously great advantages of mediation, because mediation over a period of time, we have seen that parties have used in different contexts. And what the benefit which we have really seen is that it encourages the parties to pursue the mediated settlement. And with the Singapore Convention on Mediation, and I attended the convention week last month, we had participants from across the globe coming and talking about the advantages of mediation. What it does is that with this, in irrespective of arbitration or court litigation, you can have a mediated settlement which is enforceable. Because the only fear parties have is that if they settle the matter and we have an settlement agreement, what is the enforceability? It should not lead to another dispute, which would then make parties to go into the second round of dispute. The other advantage which mediation has is the collaborative approach from all the parties to resolve the dispute, and it preserves the personal, professional, and commercial relationship, which is very, very important, because in the long-term contracts, we have seen that parties have to maintain the relationship. Just because a small dispute arises, that is not an end of relationship. Whereas in arbitration or litigation, you have an adversarial position where you don't have a win-win situation for both parties where they can continue to work together. Mediation also reduces the burden on the arbitration and the court system, because once you have a mediated settlement, it is very easy to enforce, and it's not that you have to go for a challenge of an award or file an appeal against the judgment of the court if you are having a court matter. Therefore, I see that there is a clear advantage of having mediation as one of the dispute resolution mechanism. As even if we have to have an arbitration as a dispute resolution mechanism, we have seen multi-tiered dispute resolution clause where you start with mediation, see if you can settle the dispute through mediation, but if not, then only go for arbitration. In terms of time and cost, it saves huge time and cost. It is quicker than litigation and arbitration. It is more cost effective, and it is more convenient because it allows the parties to control the time, location, and duration of the proceedings. We have seen in last 2 to 3 years, everything has happened virtually without any difficulty. And we have done number of mediations virtually. It has helped parties to also reduce the friction, because there are two views here, is that when you meet in person, you can resolve the dispute. But we have also seen that the parties have been able to resolve disputes virtually, because they don't have to sit across the table, and sometimes not being in physical contacts and being only on screen has helped parties to come to a settlement, because they don't have any personal animosity between those parties. It is very flexible. Every mediator has different style. Of course, there is a general way of handling mediation, and therefore the capacity building and training plays a very important role. And competitions like this really helps to build that confidence in all of you. Winning and losing doesn't matter. At the end of the day, the experience counts, because the process you will go through of mediation, you will have to apply your mind as to what is mediation, how it is done, and then it will make you interested in this practice area. Because what I personally believe is that this is an era of specialization. You need to at least focus on 2 or 3 aspects of legal practice once you come into profession. And there is number of people who are coming into profession every year, and you need to make mark for yourself. So if you are going for alternative dispute resolution as your practice area, then mediation has to be part of it. And without mediation, you will not be able to give complete service to your clients. Mediation is also accepted by the courts across the world, and we have seen that even mediation can have its own enforceability. Either you convert it into the arbitral award, which is possible under our act, or once we have the mediation act, which we just heard that we are in process of having an act that would statutorily recognize the mediated settlement as the way to settle the dispute. And lastly, mediation is very helpful in the sense that it is confidential, because in arbitration in India we have seen that no matter what you do, either you'll go for Section 9 for interim relief or have an appeal against the order of interim relief granted by the tribunal, setting aside of the award or execution of the award. In mediation, the dispute remains confidential throughout. India, we have seen there are a number of legislations. We heard that Sumedha told us that there are a number of legislation which provides for mediations. CPC Section 89 encourages mediation. Commercial Code Section 12A makes a mediation a requirement before starting any suit. So it's a pre-institution mediation which is compulsory, and Supreme Court has recently held that Section 12A is a mandatory provision. You cannot just do away with Section 12A. Consumer Protection Act 2019 also encourages mediation. It directs the consumer for us to refer matters to mediation by having an entire chapter dedicated to the mediation with the provision of consumer mediation cells, empanelment of mediators, and recording of settlements. Institutional mediation plays a very important role. IDRC is there. We have Singapore International Mediation Center. We have CAMP, Center for Advanced Mediation Practice. PACT is there, which is also working very closely on mediation training and capacity building and providing the services. All these institutional rules help the parties to conduct mediation in a very structured manner. We have the High Court annexed mediation centers as well, but we need to increase more and more commercial disputes going for mediation. We have seen that the mediation has been very successful in matrimonial family matters. But ultimately what we need to see is that international mediation for cross-border dispute is very important, and for that we need to have the service providers like institutions which are also recognized in the mediation bill. I appeared before the Joint Parliamentary Committee for the mediation bill, and they have come up with the recommendation. The mediation bill is under active consideration by the Parliament, and by end of this year or early next year, we would see a mediation act which would give a lot of impetus to the commercial mediation in India. What this act will do is that it will make the mandatory pre-institution mediation before filing any suit or proceeding of civil or commercial nature in any court, whether any mediation agreement exists or not. So even in absence of a mediation agreement, the parties will have to undergo a compulsory mediation. Of course, after two sessions of mediations, parties can opt out of the mediation, but at least it will give a nudge or a try to the parties who are going for a commercial dispute. A filing of a suit or proceedings before the court or tribunal seeking urgent relief is excluded, because you don't want to have a situation where just because you have to go for mediation, you are not able to approach the court for the interim relief. The enforceability of mediation settlement in the accordance with the CPC or in any other manner where the judgment or decree is passed by the court. So there is these mediated settlements are given a status of a decree passed by the court, and they are deemed a decree, and they are enforced as if they are the decree of the Indian court, which is a very important provision which we don't have in any legislation as of now. All the legislations provide for mediation, but they don't recognize the mediated settlement as a decree of the Indian court. Whereas in Section 36 and of the Arbitration Act, we have that provision of recognizing, and for foreign awards and in part 2, we have section 49, which recognizes the same. The Act also is going to provide for establishment of the Mediation Council of India to promote domestic and international mediation in India. And it will lay down the standards for professional and ethical conduct of the mediators. It will recognize mediation institutions and mediation service providers. So which that will also kind of regulate and consolidate the way the mediation services are being provided in India. We have very good institutions, but what we need to bring in is uniformity, capacity building, and standard way of providing mediation services in India. So this act is going to bring a lot of positive benefits to the practice of mediation in India. We have seen that Supreme Court has referred number of cases for mediation. Since 2005, nearly 3.22 million cases have been referred, and almost 1 million cases have been settled by mediation up to 2021. So this is a very encouraging number, because 1/3 of the cases which are being referred are getting finally settled through mediation. This brings the quick and affordable justice for all, because this is the goal of the justice delivery system. But given the size and the population in India, and we have a number of disputes which arise every time, we have to ensure that the mediation is made more and more popular in India, and that responsibility lies on the next generation of the lawyers, which we will see that once you have this training and kind of exposure to the alternative dispute resolution, when you come into practice and start advising the client, it's going to be a completely different way of practice, because what we will see that it's not always an adversarial system which brings relief to the parties. We have seen many professionals who are full-time mediators and doing very well in their own profession as well, because parties don't mind paying if their disputes is getting resolved, because ultimately what you are doing as a mediator is saving a huge amount of time and cost in the adversarial process. So we have seen that mediators are also able to practice and earn well in terms of their own practice, if you are good and able to deliver a great result to the parties. Mediator never adjudicate, it only they only facilitates the parties to come to a negotiated settlement. And therefore what has happened is that the mediation has become very relevant in the commercial contracts, lease agreements, employment disputes, of course marital disputes, and industrial disputes are it is very popular, but what we need to bring mediation is to all commercial disputes and international dispute between the commercial parties and also sovereign states. It has an immense potential to grow and in order to resolve civil and commercial disputes. It also saves time and cost, because ultimately what we need to achieve is a quicker and efficient dispute resolution mechanism. I'm very happy that all of you are participating in this competition. As I said, winning and losing doesn't matter, because what these competitions provide is training and experience, which you should all cherish, because ultimately we have to see that it builds your CV, it adds critical thinking skills, and when we see candidates for recruitment in firms, we see the overall experience which they have had during their law school days, because critical thinking skills, researching skills, and also legal writing skills, these are very important skills as a lawyer, which we all should develop. And apart from anything else, it also allows you to take a holistic view of the matters. They require you to take views and advocate both sides of the case. As a mediators, you are able to see the perspective from both sides and trying to find a solution for the parties. That is very important, because ultimately what you need is the overall development and a career development which will help you going forward. And also it helps you to meet people, network. I'm in London right now. I attended ICA conference, which was one of the largest conference till date of having 2,000 lawyers across the globe. And there also, apart from arbitration, everybody was talking about mediation. They were quite curious is how India is going to tackle the mediation aspect of that. And there is also the future of dispute resolution lies in mediation, where all of us will have to ensure and increase the confidence in this mode of dispute resolution. I'm very happy that you have pushed yourself outside your comfort zone and taken this challenge of attending and participating this mediation competition. I wish all of you a very best and a very good experience. I'm sure you will learn a lot from this process. And I congratulate each one of you, irrespective of who is the winner of this competition, and wish you all the best. Thank you.
Thank you so much, sir, for your kind, encouraging, and informative words. I am extremely sure that all of us would have learned a lot from your knowledge and experience. I would now request the Honorable Director of CADR and Area Society, Dr. Santosh Kumar Sharma, to present his vote of thanks to our honorable guest.
Sir, sir, kindly unmute yourself, sir.
Thank you, Kanishka. And I'm really happy to hear all of you that your words of encouragement and information must have been very helpful for all the participants. And the purpose to have you all here, I think, has been served with great like encouragement to all the students, participants. And on behalf of the university, I extend my thanks to all the esteemed panelists or the dignitaries here. First of all, I would like to thank Mr. Our chief guest, Mr. Tejas Karia, sir. Thank you so much, sir, that despite of your busy schedule, you spared some time to share your views with all the participants and this young generation. As all of us are basically or primarily aimed to encourage the coming generations, young lawyers. So for that, I thank you, sir. On behalf of the university, thank you so much, sir. It would be a great pleasure to invite all of you to this campus in the time to come. And I thank Ms. Anupama Walia, madam. Thank you so much, madam, to spare some time from your valuable schedule. And thank you once again. Thank you so much, madam, to share your views with the students, with the participants. I thank our special invitees, Dr. Shantanu Mukherjee. Sir, so thank you so much, sir. Thank you so much to be here virtually, but it was not lesser than anyhow that. And so thank you so much, sir. And Madam Sumedha Rathi, thank you so much for being here. So on behalf of this Center for ADR and Professional Skills, though there was earlier, as Shantanu sir referred this, earlier there was a question or debate when we were thinking about having a center for ADR, that whether we should go with the term professional skills. So ultimately all agreed, and we had have the proper term added, that professional skills with CADR. Though in that direction we have not been very successful so far because of this pandemic, but we have started uh, in that direction, that and hopeful that we will be able to invite people like you to share your thoughts and train the young generations. Thank you so much, sir. Thank you so much, madam. Thank you, everyone, all the participants. We wish you all the best for the competition. Thank you, everyone, for being here. Thank you. Kaniska, over to you.
Thank you, sir. Now I'd like to invite Ms. Pakhi Jain, convener, Center for ADR, to present her thank you note to our honorable guests. But before that, a kind note to all the participants. All the participants have to stay back in this meeting for a technical session run. Thank you. Ms. Pakhi, please take over.
Good afternoon, everyone. This is Pakhi Jain, student convener of CADR. I feel honored and privileged to get the opportunity to propose a vote of thanks on this special occasion. I would like to thank all the honorable panelists who blessed us with their presence. We are honored to have you all with us in the second National Mediation Competition organized by Himachal Pradesh National University. I, on behalf of the organizing committee, want to convey my heartfelt gratitude to all the guests for accepting the invitation and presiding over the inaugural ceremony. I would like to thank Mr. Tejas Karia, Ms. Anupama Walia, Mr. Santanu Mukherjee, and Ms. Sumedha Sindhu. My special thanks to our director, Mr. Santosh Sharma, for always guiding us. I am very much thankful to our members of CADR for their support. Without further ado, I would like to declare the NNC 2022 open and wish everyone the best of luck to experience the field of mediation and deliver a great performance. All the best, everyone.
Thank you,
Kanis-
judges. Thank you so much for being here today.
Thank you.
Thank you. Thank you very much.
I want to request all the participants to stay back for the technical run. We have rescheduled the technical run for right now, and we don't have the SCC session that was scheduled for the participants. Thank you. Am I audible? Guys, am I audible? If someone could just give a heads up.
Yes, Saloni, you're audible.
Okay, thank you. There is some technical issue with the sharing of screen. So before that, I just want to inform you all that when you join the session, it is a humble request to all the participants to kindly rename them with their team code and the role assigned to them. If you are willing to take some, it is for the mediators. If you are willing to take some fake name, kindly make sure that you write yourself mediator 1, mediator 2 in the display name, and you can use any other name to have yourself, like to just recognize yourself in the session. But the display name should be your team code and the role assigned to you. Now with that, if it's a problem that how to change the display name, you are required to do that by going to the settings of your account. You cannot change the display name after joining the session. So make sure before joining the session you edit the display name in by going to your Google accounts settings, and there you can change the display name. Other than that, we are just here to tell you that we'll be organized, as there was a query that there are two sessions going on at the same time in the same room, and one link is provided for that. So we are going to have two sessions in the breakout room. So we'll be creating two breakout rooms in the one session, like one link that will be the main link, and there two breakout sessions will be there. And in that two breakout sessions, two different sessions will be going on. In room one, both the teams that are required to be there for the session, both the negotiating pairs and the mediators are required to join room one, that has been allotted to that particular team. And room two is required to join by the mediators and the teams that are in that is allotted to that particular team and the mediators. So when you will be coming to joining that main link, you will be asked to wait in the waiting area, that is the main session. Both the mediators for both room 1 and room 2 will be asked to join their respective rooms. Once they'll join their respective rooms, they have a half an hour time to have a discussion and to divide their mediator speech. Later on, the negotiating pair and the mediating pair, that is the requesting parties client counsel pair and the responding parties client counsel pair, they'll be asked to join the particular session. They'll after that, when we have the judges for the particular session with us, we'll start the session. And during the caucus, where a particular team will be calling a caucus, the other team that is supposed to be out of the room, they'll be joining the main session. And later on, once their caucus ends, then then the team that is having the caucus before will join the main session, and the team that is in the main session will join the room for the caucus. So this will be shown to you by Hamza, who is presenting the screen. He'll tell you how to join the caucus. It's a very simple process, and we just require you to understand that right now so that it is easy for us to conduct the competition tomorrow. Thank you. After that, if you have any other question or query, you can ask us. Thank you.
Uh, Hi everyone. Uh, I think you should probably be able to see the screen that I'm sharing, and you'll see that I've created two breakout rooms called room 1 and room 2, and I've placed Abhyuday, who's been nice enough to lend us both his accounts. I've placed him in room 1, and I've placed another person in room 2. For example, I can add another person who goes by. Okay, let's try Mr. Ayush Raj. Okay, I'll add him. And this way we'll be conducting two separate sessions. I think some of you had some queries regarding that yesterday. So we'll be conducting two separate sessions in the same Google Meet with two breakout rooms. And once I open these rooms, then we'll go there, and I'll be joining the main call again. So as you can see that I'm in the breakout room, and as you can see that I'm in the breakout room, and then there are. Oh yes, Abhyuday also, he's left one of the rooms. Doesn't matter. As you can see, Abhyuday, there's a person in room 2, and that's how they'll be the sessions will be conducted. And when the caucus is in session, you'll have the option to join the main call. Mr. Abhyuday, sir, please can you join the main call again? Just a second, please. So he's in room 1. Abhyuday has joined room 1 again. So that's how the sessions will be conducted. And if you can please, when the caucus is in session, when either the negotiating pair or the mediator calls for a caucus, they'll be able to go to the main call again for the caucus. The caucus will last for 5 minutes. Mr. Abhyuday, please can you go to the main call again? So yes, as you can see, I think yes, Abhyuday has joined the main call again, and that's how you'll just be able to join the main call, and that's all there is. It's a very simple process, and there's not much else to it. I think Google Meet is the rest of it is just as Google Meet normally functions, and there's not much more to it. So yes, do any of you have anything that you want to ask?
Guys, if you have any query, you may ask by raising your hand and we'll address that query. We just wanted to show you how to join the breakout session and how to do the whole thing. So if you have any query, you can ask. Guys, if you have any query regarding the competition, how you're supposed to join the session, how it is going to be conducted, you can ask any question and any query if there is anything.
Guys, if there are no more questions, I think we'll be ending this meet.
With this, we request all the team members to kindly leave the session as we are ending this session. And thank you so much for joining us. And have a great day. And we are not going to have the SCC session due to some issues that came up. Okay, thank you so much for your presence.